I'd like to call the meeting to order. Welcome to the meeting of the San Francisco Ethics Commission, January 23rd, 2012. We'll take the roll. Commissioner Studley.
Here.
Commissioner Liu.
Here.
Commissioner Han.
Here.
Public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
Good afternoon, Commissioner Herr and Commissioners. My name is Patrick Manetshaw, and once again, I do not see my agenda item on the agenda. That would be for the Sunshine Task Force referral for enforcement on case number 11013 and 11014, which was sent to you 5 months ago. You have not yet scheduled a public hearing on my item, and it should not take you 5 months to either recuse Mr. St. Croix from this case, since the task force sent it over with a finding of willful failure and official misconduct against Mr. St. Croix on both cases. So for him to recuse himself and this body to schedule a hearing on my case, I'm wondering when you're going to tell me, Commissioner Herr, when you're going to schedule my hearing on the agenda.
We'll look into it, Mr. Shaw. Thank you for bringing it to my attention.
I'm sorry, I have a hearing loss since birth. I didn't quite catch that.
I said thank you for bringing it to my attention. We certainly will look into it.
That would be the third time I brought it to your attention, sir.
Alan Grossman and I've appeared maybe six or 8 times before this body. The Ethics Commission is the only city body empowered to enforce violations of the city and state public records laws. Yet from 2004 through 2011, without holding a single hearing or taking a single vote, the Ethics Commission rejected every one of 26 public record enforcement cases sent it by the Sunshine Ordinance Task Force. During that 8-year period, the Commission membership has turned over almost 3 times, and the Commission has held over 100 meetings. The only constant player in all these 26 rejections over the entire 8-year period has been John St. Croix, your executive director, wrongfully using the Commission's ethics inapplicable regulations and its default provisions. He handled the entire process from start to finish without the participation or involvement of even one commissioner, managing any staff investigations, determining whether there was probable cause for a commission hearing, selecting the facts for his report and recommendation to the commission, and sending the so-called dismissal letter. No hearing, no vote, case closed. His views of the task force are no secret. Last March in the New York Times, he said the work of the task force often lacked due process and that his department had an obligation to review the cases. That statement was blatantly false. He knew that. The task force has an exhaustive due process procedure, including at least 3 hearings. The Ethics Commission, on the other hand, has none. That statement and others in the article was a gratuitous comment intended to discredit the task force work and disparage its members. Prop 59, adopted in 2004 by an 83% majority, created the public's constitutional right of access to public records. The Commission's complete lack of involvement in these cases and the executive director's misuse of his position has denied those 26 complainants that right. I think the time has come for this body to recognize that that right exists. Thank you.
Good evening, Commissioners. My name is Dr. Allison Washburn. I'm a member of the Sunshine Ordinance Task Force. I occupy seat number 5 and was appointed by or recommended by the League of Women Voters of San Francisco. I also chair the Compliance and Amendments Committee of the Sunshine Ordinance Task Force. I appeared before you in November at your regular meeting to urge you to meet with us jointly about your proposed regulations for handling sunshine enforcement cases. And I think that the consensus seemed to be from you that that would be a good idea. I then sent a letter. It was dated January 6th, 2012, asking for a joint meeting, suggesting the week of February 6th. It's probably too late for that to happen. But I'm here today to, again, request a joint meeting. I think that the matters before us are complicated. The history between our two bodies is strained. We look to the Sunshine Ordinance Task Force, and citizens look to you to help enforce the city's public records laws, and this hasn't been happening. So I hope to hear a response to my letter in a few days' time so that we can schedule a joint meeting. Thank you so much for your consideration.
Thank you.
Thank you very much for the time clock. And it's a little bit alarming that even though this meeting is relatively sparsely populated, the handouts are already exhausted. I begin by saying stop the corporate rape of the public library, don't give money to the Friends and Foundation, don't accept money from the Friends and Foundation. You may remember that this commission at its meeting in July found that the president of the Library Commission had committed a willful violation and her conduct was below the standard for a public official. Later that month, the Library Commission, during a discussion of a copier service for the public, one of the commissioners said, and I quote him verbatim, "You know, last Monday when we had met," the commission meets on Thursday, "last Monday when we had met, the commissioners had met, we talked about how the changes to the printing system would potentially impact the staff as well. I was just wondering if it would be worth it to speak to the public about how this impacts the staff as well." You don't have to be a genius to figure out that this is a blatant admission of a non-announced meeting among the commissioners. It goes without saying that there was no announcement of a meeting on a previous Monday and no explanation offered about why this was not a blatantly illegal meeting. I mentioned this several times. Of course, my mentions of it were never documented in the Library Commission's minutes. Finally, at a meeting of December 15, that same commissioner said, again, into the microphone, and I transcribed him directly, "There is just a thing in reference to an illegal meeting, which was simply a briefing. I just want it to be clear, there's no such thing as an illegal meeting. It was purely a briefing." Well, this is an example of them simply flaunting their power. They have a commission president who's been found in willful violation. You have no concept of how corrupt these people are. I certainly have found nothing comparable in society. They are ripping off a public institution of millions of dollars, and a finding of being unethical or violating sunshine ordinances and laws is just an opportunity to show how impervious they are and how weak any sort of democracy is compared to the influence of money and corporate power that they possess. The fact of the matter is, if you come to this Ethics Commission meeting and just shuffle paper, you need to be aware of how much damage you're doing because you're demonstrating how powerless democracy is. And of course, the lies cost more than the money. Thank you.
Good evening, Commissioners. My name is Dr. Derek Kerr. After 20 years at Laguna Honda Hospital, I became a whistleblower, and then I was laid off. In the past 6 years, you've dismissed 29 consecutive sunshine complaints. Even though you substantiated 20% of them, none resulted in any enforcement action, and only one was granted a public hearing. All of them were dismissed. This wrongly implies that the complaints were not valid, and it also allows city officials who violate the Sunshine Ordinance to claim that they were exonerated by the Ethics Commission. Your handling of whistleblower retaliation complaints is similarly one-sided. Every single retaliation complaint has been dismissed since the Commission was founded. Meanwhile, the Government Accountability Project has provided legal aid to some 5,000 whistleblowers over the past 30 years. Here's what they advise in their Whistleblower's Survival Guide. It says, you will surely suffer retribution for blowing the whistle because bureaucracies instinctively eliminate anything perceived as a threat. Academic studies confirm that more than 90% of whistleblowers report subsequent retaliation, and they give references. Now, if experts say that retaliation occurs in 90% of the cases, why do you report a retaliation rate of 0? Please consider two possibilities. Number one, your investigations are biased against complainants. And number two, your decisions are based on opinions from the city attorney, who has a duty to defend the very same city officials that we report for wrongdoing. Thank you very much.
Good evening, Commissioners. Doctora Maria Rivero, I was pushed out and forced out of Laguna Honda after 22 years of service to the city. 2 years ago, we made 3 whistleblower complaints to the Ethics Commission. The first one regarded Health Director Mitchell Katz, who was at the time making $10,000 a year working for Health Management Associates, a for-profit corporation that had a contract at the very same time with the health department that Dr. Katz was running. This complaint was dismissed by Ethics. Our second complaint regarded Davis Jaw and Associates, who was awarded a $2 million Department of Public Health contract. Davis Jaw's wife, a high-level DPH executive, played a major role in awarding him the contract. After 2 years, the controller revoked Jaw's contract, citing, quote, irregularities, unquote. This complaint was also dismissed by the Ethics Commission. The Laguna Honda Gift Fund was reported as well. It's a charitable trust for poor patients that was being plundered for staff parties and perquisites by the Laguna Honda administration. 9 months later, and a lot of public pressure resulted in a controller's audit that restored $350,000 to the patients of Laguna Honda. But again, this complaint was dismissed by the Ethics Commission. And lastly, I was driven out of Laguna Honda after 22 years, and Dr. Kerr was laid off. Our whistleblower retaliation complaints were dismissed by Ethics without a hearing. Is this ethical decision-making? Thank you very much.
Good evening. I'm Peter Warfield, Executive Director of Library Users Association. First of all, I want to thank the Ethics Commission today on its inauguration of publicly televised meetings, which will make it much easier for the public to observe what is happening at your meetings compared with audio only. I hope that the Ethics Commission will continue progress in the direction of open government by improving in a variety of other ways, and especially by having public hearings on issues referred to you for enforcement by the Sunshine Ordinance Task Force. That's an area where I think you have an unfortunate record. A case that I brought against the public library in 2004 is one of the first that was referred to you that was included in the group that Alan Grossman's lawsuit brought. The issue there was the library's refusal to provide workers' comp records, even redacted, to prevent any kind of confidentiality harm. Records that would confirm or unconfirm their claims about a very important issue, and that was, what are the health risks of barcode swiping for employees? They were claiming that swiping barcodes to demagnetize books when people check them out was causing repetitive stress injuries that were harmful, bad, and so on, and even crippling to employees. When we asked for the documentation that would back this up, they refused to provide it. And after a lengthy follow-up process, including their refusal to attend Sunshine Ordinance Task Force meetings, at which specific members of the library staff were requested to attend, the Sunshine Ordinance Task Force referred this matter to you for enforcement. I was unaware of any process whatsoever. I was unaware of any hearing whatsoever, and ultimately found out that a letter had been sent using the phrase, which I don't have before me, dismissing or no violation found, as though the Ethics Commission had actually had some process in place. It was pretty shocking. And I wanted to tell you about the real-world consequences of this, which I think is important for you to recognize. This isn't just a piece of paper over here and another piece of law over here, and do they or do they not match up, but there were very significant consequences in the real world that hurt library users. Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. As documented in a recent civil grand jury report, this Ethics Commission has failed to carry out any responsibilities related to the Sunshine Ordinance. Through this failure, the Ethics Commission has sided with the city and against the citizens in every case where public comment was prevented and public records withheld. Not only has this Ethics Commission failed in its duties, it has willfully and knowingly thwarted the efforts of the Sunshine Ordinance Task Force. It has done this for years while misrepresenting its efforts as trying to work with the task force. It has been derelict in its duties in allowing the staff to dispose of every case without a hearing. The members of the Ethics Commission, after taking an oath to support and defend the California and the United States Constitutions, has acted in ways that knowingly and willfully violate the constitutional and civil rights of the citizens of San Francisco. Now, some may feel that I'm being too harsh in this, but I think the prior speakers and myself have really looked at the records, and for the first time we are now on the public record so that the citizens of this city can actually see what this Ethics Commission has done up until now in the dark. And I will quote Senator Barry Goldwater in his 1964 presidential acceptance speech of the Republican nomination, where he said, "Extremism in the defense of liberty is no vice, and moderation in the pursuit of justice is no virtue." You have not done your job as far as Sunshine and the citizens of this city. You took an oath to support and defend the Constitution, and yet when citizens come to you and say, we were denied an opportunity at a public meeting to meaningfully comment and participate, you ignore it. You side with the city 100% of the time. Now, it's kind of hard to argue with that record as being one that is totally unjustified.
Hi, Commission members. Kimo Crossman here. First of all, I wanted to congratulate you on having televised version of this meeting that's long overdue. I'm glad that you found money in your budget for it. I wanted to say that I am sad to see the poor record you have to date on enforcement of sunshine referrals. Almost every one that's been sent to you has been dismissed without a public hearing and without even regulations in place to dismiss it. I would strongly encourage you to have a joint meeting with the Sunshine Task Force to work with them on the regulations that are needed to be designed to handle sunshine matters. And I would advocate that you do significant work in protecting the public's right to speech as well as right to documents and whistleblowers.
Good evening, Hal Smith. I'd like to thank you and congratulate you on starting the televising the meetings this evening. It's a great beginning. I congratulate you and thank you once again. It's good for the citizens of San Francisco. It's good for democracy. It's good for citizenship. It's good for open government. But it's also good for you because it gives you a chance to tell the story of the Ethics Commission. It gives you an opportunity to be out front, strong, noble people working for the benefit of the citizens of San Francisco. Today, it's my understanding, I have lots of Chinese friends, it's the year of the dragon. Dragons are strong. Dragons are wonderful people who believe in the strength and character. I consider this your beginning. Since you're televising tonight, I guess it's your birthday. It's the beginning of something. Be strong like dragons. Do the right thing. Protect the citizens of San Francisco. Protect their rights. Protect open government. Thank you.
Good evening, Commissioners. My name is Hope Johnson. I'm the chair of the Sunshine Ordinance Task Force. I'm here to reiterate what Dr. Allison Washburn said, the chair of the Compliance and Amendments Committee, to request that you consider having a joint open meeting about the Ethics Commission's regulations on sunshine. I think that even though the ethics staff clearly disagrees with us, that there are a number of things that you might want to take into consideration. There are a number of things that happen within the city that demonstrate that the ethics staff's opinion that it's only willful violations is a little bit misleading and perhaps incorrect because, first of all, the Ethics Commission is tasked with collecting up all of the signatures stating that the required employees and elected officials and public officials have taken sunshine training. So you're clearly involved. And in Section 15102, Rules and Regulations, which is specifically to Ethics Commission, it says, in addition, the Commission may adopt rules and regulations relating to carrying out the purposes and provisions of ordinances regarding open meetings and public records. And the individual clauses of the Sunshine Ordinance don't work outside of the law, the other laws, the California Public Records Act and the Brown Act. And you're also tasked with upholding those. It's not just individual provisions that you can argue to entangle them or unentangle them depending on what you do or do not want to do. And I don't know if the ethics commissioners, as commissioners, want to rely solely on staff without really investigating it with people who hear them all the time. In addition, in C369911 under duties, the appendix to Section 15100, it says that one of your duties is to advocate understanding of the charter and city ordinances related to campaign finance, conflicts of interest, lobbying, governmental ethics, and open meetings and public records, and the roles of elected and other public officials, city institutions, and the city electoral process. And I think the fact that they put open meetings and public records in there is really demonstrating that your responsibilities are more than just willful violations. So we would appreciate the opportunity to discuss that with you, with the commissioners themselves, rather than going through memoranda from the ethics staff. Thank you.
Good evening, Ethics Commissioners. My name is Thomas Piccarello. I am also a victim of your staff's dismissals of one of the orders of determination by the Sunshine Ordinance Task Force. I won't go into the merits of the case. You have the records, but the statistics cited by Mr. Grossman and Dr. Kerr are very troubling in terms of the dismissals of all Sunshine Ordinance orders of determination. You know, for the members of the public that are watching the proceedings, they should be advised that the Sunshine Ordinance Task Force makes a determination when there is a violation of request for public records or not being able to participate in public meetings. The Sunshine Ordinance then also gives you the responsibility to review the orders of determination by Sunshine Ordinance Task Force. The statistics by Mr. Grossman and Dr. Kerr would support the assertions that the Ethics Commission, at least in the past, has been biased against individuals who have shown that their rights have been violated, either open meetings or public records. So my suggestion to you is that you put the matter of enforcement or lack of enforcement of orders of determination back on your agenda. Thank you.
Thank you to the public for your comments.
President.
Please, sir, proceed. Please, proceed.
Well, I think the thing is that I have been assaulted by some of these staff of the city and county of San Francisco. I have been kicked out of meetings just for showing up. I have been not given many documents. I don't know why. I just feel I shouldn't have to call Trent Rohr or David Cardle or any of those people to get the documents I need. I think it's definitely outlandish. I am hoping that y'all decide to hold somebody accountable. I mean, I definitely believe that you're making the city and county of San Francisco spread eagle for whatever lawsuit that comes by. And the citizens need to start filing. They need to start filing immediately. These statistics that you're presenting, it's innately unacceptable.
Thank you all for your comments. With respect to the Sunshine Ordinance Task Force, we do look forward to meeting with you, and I believe it is our intention to do so. I think when we last addressed the issue, Richard Nee suggested that we try to do it in the coming year, not sort of at the end of 2011, to ensure greater participation, and we look forward to having such meetings so that we can, get the sort of regulations that we can hopefully agree are effective and efficient. The next item on the agenda is proposed amendments to the SIA for the San Francisco Public Library. Mr. St. Croix, would you like to introduce this issue?
Yeah, we started consideration of these proposals last May. There were some questions commissioners had about the appropriateness of the language as it applied to not just staff, but excuse me, officers. So we've gone back and forth with the library staff and commission, and have determined that there's sufficient grounds to reintroduce this proposal to the commissioners, including officers in the language. And I believe is Donna Marion from the library is here to answer any questions you have.
Great. Ms. Marion, would you like to make some remarks?
Donna Marion from the library, the Human Resource Director. The library still feels that, yes, we would like the SIA approved as is. We do already have regulations in place for our collection and plan policy, as well as our exhibit policies. We have already established guidelines that address your concerns that have been established for quite some time within the library, so we were hoping that you would move forward and approve the SIA as presented.
Thank you. Any questions for Ms. Marion? Commissioner Liu?
Thank you, Ms. Marion, for coming today. Can you walk us through a little bit how, the commission's role as opposed to the department head's role in terms of approving contracts, or how that's done and how if it's separated?
Yeah, it's separated. The commission has no involvement in improving library contracts.
So there wouldn't be an occasion where someone who wants their work published, they would be in a position to influence the decision to contract with that vendor or that publisher?
Not at all.
Okay, thank you.
Any other questions for Ms. Marion? Thank you.
Thank you.
I'd like to take public comment on this matter.
Yes, thank you very much, Commissioners. And of course, don't give money to the Friends and Foundation. Don't accept money from the Friends and Foundation. This is actually a little more complicated than it seems. What's being represented or kind of masked as a potential author might want to write something, the publisher might be involved, is actually a wide spectrum of vendors, not just of somebody who might want to publish a book. There are digital vendors, digitalization projects, all kinds of exhibition projects, copier vendors. There's a wide spectrum of people who do business with the library, and they not only do business with the library, they do business with people who have another level of influence, which is the public-private partnership they have with a private nonprofit. And in fact, if you look at what's being proposed here, is an exemption that can already be exempted on a case-by-case basis by seeking a prior determination. So you're actually stepping back from a level of review that ought to apply to every department. In fact, a librarian or a library commissioner is no more or less likely to write a book than a nurse in a hospital or a gardener working in Golden Gate Park. And as I say, the provision is that they can get a prior determination on a case-by-case basis that there's no actual conflict when that comes up. I expressed some concerns before because the incompatible activities statement that had been in place since 95 or whenever it was completely ignored in this process and still has not been rescinded. I guess you're considering it rescinded as a de facto fact, but I wish this had been originated through the Library Commission rather than referred to them as a fait accompli, which is kind of the way it was presented. As I say, this is not a bunch of little authors getting their exemptions for one little book. This is a big business and big players involved. And we need the kind of oversight that this whole idea of an incompatible activity statement envisions. Thank you very much.
Commissioners, Ray Hartz, Director, San Francisco Open Government. And unfortunately, when I review these things for a meeting, I always have a tendency to read the entire thing, not just the part that's under revision. And having attended Library Commission meetings for the last couple of years, I happened to read something in here and came to the conclusion what you're doing here is rearranging deck chairs on the Titanic. Section 5 says prohibition on gifts for assistance with city services. No officer or employee may receive or accept gifts from anyone other than the city for performance of a specific service or act of the officer or employee would be expected to render or perform in the regular course of his or her duties, or advice about the processes of the city directly related to the officers or employees' duties and responsibilities, or the processes of the entity they serve. I just recently, in December, had a finding of a sunshine violation against Luis Herrera, the city librarian, for withholding public records. He was very, very careful to send all of my requests to him, to the secretary of the Library Commission, who then sent me all the information from the Friends of the San Francisco Public Library. Now, they withheld all of the information which would appear in documents that the city librarian is required to provide to the mayor's office, the comptroller, and other city agencies, and simply gave me the numbers that the Friends provided, which are not audited. The interesting thing was, if you look at some of the categories, and then you look at this item, Mr. Herrera gets approximately $65,000 a year from the Friends for use at his discretion. $30,000 for public relations, and another 35 or 36, depending on which year you're talking about, for use totally at his discretion. So in other words, they give him a nice big fat check, and he buys things like office supplies. I guess the library in the city doesn't provide him with office supplies, so the Friends has to give him $35,000 a year to buy those. And he takes the staff out to lunch, and he has this, and he has that, and he goes to conferences, all of which are related to his duties, but all of which have also, I believe, put him in a position where he withholds information about the Friends and what they actually turn over of the $4 to $5 million a year they raise, and what actually makes it into the coffers of the city library. So far in the branch library improvement program, they committed to a $16 million contribution. So far, they have given $1.4 million, although 88% of the branches are completed. And every time Mr. Herrera is asked for an explanation by the Library Commission, he makes excuses and demurs.
Peter Warfield, Library Users Association. The previous speaker has certainly touched on some issues that are very problematic and which I certainly think you should keep uppermost in mind. I didn't come particularly to comment on this, but I do think I have some observations to make for your consideration. First of all, the library typically does not buy books from publishers. They buy them essentially from jobbers like Baker and Taylor, who provide them a whole ton of books from a whole variety of publishers so that they can deal with one vendor and by and large don't have to deal with the many, many, many publishers that exist. If they have a problem with a particular title, they could easily go to a bookstore or a jobber and get it that way without having a direct connection with a publisher. The elements that you appear to want to cross out from Section 3A, restrictions that apply to all officers and employees, seem to me to be somewhat problematic as well. And in fact, number D, as in dog, seems to me to be insufficiently restrictive even as it stands. It should be much broader. It says no employee of the city or the city librarian may serve, whether compensated or not, as a consultant, exhibition designer, or preparator for a company, nonprofit organization, artist, or artist collective whose exhibitions are booked into the library. Well, I think that the final phrase ought to be stricken altogether, and that D should stand. They shouldn't be serving anybody who has a relationship with the library, particularly where there's money involved, as, for example, the Friends. It shouldn't just be for the folks who have an exhibition. Section E, as in Edward, following that, talks about no employee or the city librarian may be employed or buy or provide services in exchange for compensation as an instructor for any person or entity that provides training at the library. Well, there's no reason why an employee should be an instructor for a, as an example, technology vendor at the library. I think that's a clear potential conflict of interest. So I think that all of these things that you're looking to strike are not really issues, and in specific cases, certainly the library could seek an exemption. I do think that these are conflicts that are problematic, and in the case of D, should be strengthened rather than weakened. Thank you.
Good evening, David Pilpel. A couple of items on this, and I recall my testimony back in May when we last discussed this issue. On page 1, there's a proposal to add some of the library policies as references. That's fine. I just think it's important that those policies either be hyperlinked in the document if it's available online, or be available on the library's website so that they're easily accessible. And one of the items there, the Library Bill of Rights, it's not clear to me if that's the San Francisco Public Library Bill of Rights or if it's the American Library Association Bill of Rights. It may help to clarify just whose Bill of Rights that is. On the pages 2 and 3, the language that's proposed to be stricken as it reads now, I think it would just replace A through E with reserved, and then there's an A that appears again on page 3 next to E, so I'm not sure if it is the staff's intent to have something hanging there or not. Sorry. And on the substance, it does seem to me, even if the general restrictions are proposed to be eliminated so that a member of the commission or staff can be a published author and the library can buy their book to circulate, which was part of the intent here, that there may be other examples that are embedded in this A through E that really do conflict with official duties and should remain, even if they repeat and codify more specifically with examples, things that would appear from Government Code 1090 or other prohibitions, such as being involved in a contract with and being compensated by a vendor who contracts with the library generally, like the bookbinding example. So I think that those are continuing prohibitions that exist elsewhere, but this is perhaps the best way to repeat and codify those, because those other documents don't have the kinds of examples here that your staff has ably and nicely crafted to guide the conduct of officers' employees. So I would encourage you to keep some of this as we try to eliminate those problematic prohibitions. Thank you.
I'm actually here for the next agenda item on CFRO, and there's no more paperwork about what we'll be talking about. Is it possible for staff to get more before that agenda item? Or maybe you have more.
Do we have any extras? Commissioners, any comments with respect to agenda item 2? Commissioner Studley.
This is more in the nature of a question, and it may be for Ms. Ng or Mr. Shen. We know that there are general conflicts policies that apply to all city employees above and beyond the SIAs. And it would help me to understand something about the scope of those, whether they really are a more general version of the same kinds of things that are in the sections that are proposed for deletion here, or how you think they would operate in effect in situations of the kind that are described here.
Deputy City Attorney Andrew Shen. They're just different. I think they're both broader and narrower. So, for example, one conflict of interest law the Commission is familiar with is the Political Reform Act, which we also enforce through our local law. In general, that conflict of interest law prohibits city employees from participating in a process which affects their financial interests. And one significant difference between that statutory scheme and these restrictions is that, at least with the Political Reform Act, you need to be part of the decision-making chain before you have a conflict and you're prohibited from participating. So that's one way in which that's different. So these restrictions, as you read them, don't necessarily apply to just to those people who are on the decision-making chain. And I think that was where Commissioner Liu's question was going before. These are just much more broad. You don't even need to be part of that process on the library's end to have these rules affect you. And I would say that these are also, in some ways, broader, there's many other differences, I think. I mean, one way in which they're different than, say, the Political Reform Act is that the way to deal with a Political Reform Act conflict is to recuse yourself from that process. And whereas here, there's a completely different process, as you're well aware of, about getting advance written determination, getting that considered by the appropriate decision maker at the department. So it's just different in many respects. But I would say, in general, they're kind of targeting the same things. The Political Reform Act does try to prohibit, city employees and officials from somehow benefiting themselves, sort of at the end of the day. And I think that's what a lot of these restrictions go towards themselves. But it's hard to say they precisely overlap. But there are ways in which these kinds of concerns are addressed through other existing conflict of interest laws as well.
I have another question. It's been a while since we were approving a whole series of these SIAs, so I have forgotten whether this was a standard as part of it. Clearly, throughout the ethics laws, the notion of appearances, what it looks like to the public for somebody to be involved in multiple activities, even if there is not a formal or absolute either chance to influence the decision or specific benefit to the person. Anyone who can help me with this, it's a toss-up question. Are appearance issues part of what we are trying to cover through the SIAs?
Ms. Singh?
The answer is no. We're not really dealing with appearances. We're really dealing with those incompatible activities that departments have identified in the SIA as being incompatible or inconsistent with the mission of the department, in this case, the public library. So many of these provisions that we have here really are covered by some of the policies that are listed, that are now listed, such as the collection policy, the exhibitions policy. Those really set out ways by which certain of these matters are handled, certain processes are handled by the library, and therefore I think the library feels that because we have those things in place and because the provisions as they now stand really prohibit a lot of the employees from doing the things that lead to like greater participation in the community, for instance, and the things that they want the library staff members to do, that perhaps it's not the best, that having these provisions in the SIA is not the best thing. Does that answer your question?
It does. And so my final question is whether the waiver process would suffice or whether there are activities or a range of concerns that the library is worrying about and thinks would be problematic. I'm just trying to understand the cost if we were to leave these in place and ask people to seek waivers. Clearly, they could return again if that proved cumbersome or they had a set of examples. So I'm just wondering, and we may want to ask Ms. Marion to come back. Possibly others have questions for her as well now, about whether that is what the pros and cons would be to letting the library take a little longer with the rules this way and deal with matters case by case if they came up and fell within these provisions.
Ms. Marion?
Dealing with the matters case by case, it was felt that if we could just have the rule established, or rather have the SIA indicate the position that we could be excused from doing a case by case matter, because I believe that there would be numerous case by case situations that would be brought forth to the city librarian, and it's my understanding that he wanted to get it established in the SIA. So I'm not sure I'm answering your question.
Would it be appropriate to ask for examples? I don't want to be too intrusive, but I'm just wondering what kinds of activities the library wants people to be able to do that are covered by this that would be permitted if these were not in place. Since we're at least hearing from public comment that the example of a book and a publisher may not be the particular one that you're anticipating.
Well, it was the one that we were.
Yeah,
that's the one that we're anticipating, that it was maybe because someone was an author of a book or something like that.
If that is the principal one, then there are several here that don't go to that kind of situation, and I wonder if those could be left in or leave them in and see what the experience is. I think the book is almost the most obvious because the book appears in the library with somebody's name on it, and you can trace how the acquisition decision was made. The Library Commission is not deciding, I would imagine, one by one what books to purchase.
Right, we are.
So if that's the issue that you're trying to correct, it seems that possibly dropping all of these is overbroad relative to that concern.
If I could add, when the city librarian contacted us about this, there was a suggestion made that if we could drop most of these provisions, the provisions that they would not mind staying in are provisions as a sales representative, purchaser, or publicist for a publisher. Those types could stay in. But what they were concerned about was if you had a prohibition against somebody being an author or an editor, that would really have a major impact on the development of library staff. But we can think about going back and perhaps retaining what is, like, for instance, what is in B, parts of B.
Right. The sales representative. If it's writer, editor.
Right.
I think that would be acceptable to the city librarian.
What about publicist?
Yeah, I believe that the publicist was included.
As one
sales
name.
representative, publicist, and
purchaser.
Yes.
So has the city librarian been dealing with this in the meantime with AWD waivers, or have there been waiver requests?
It's my understanding that there's been some waiver requests. Yes.
And that the librarian has granted those, I imagine.
Yes.
Any further questions for Ms. Marion or comments from the commissioners?
I guess I would like to see that tailoring, that narrowing. I think there is, some of these seem problematic, but the author seems least troubling and most likely to recur frequently. So that would be my own suggestion.
I'd agree. I'd be inclined not to eviscerate the whole section and just do what we need to do to address the primary concern, especially, I mean, if the AWG waiver process has been working, I'm not sure we need to just completely eliminate the entire section and just tailor it. I would want to more narrowly tailor it as well.
I have no objection to that. I certainly think narrow tailoring is appropriate, and to the extent that, Ms. Marion, you're telling us that these particular, taking out just sales representative, purchaser, and publicist for some of these subsections would still get to the conduct that you're concerned with, I think we should make it as narrowly tailored as possible.
Okay.
So what would be the process then going forward, Ms. Singh, if...
What we'll do after tonight is meet with library staff again and come back to the commission with new language.
Okay. Thank you.
Thank you.
Oh, I'm sorry, Commissioner Han.
Yeah, sorry. Are these provisions then going to apply to commission members as well as employees?
That is
that the
that is the
recommendation?
proposal. Perhaps we should address that as well, as Commissioner Han suggested, so that we can provide further direction to staff if necessary. My view, based on the memos and hearing from Ms. Marion, is that the other regulations governing this process sufficiently protect against the types of abuses that we're concerned about, both for employees and for commissioners. But I'd welcome the comments of my fellow commissioners on this issue.
Well, again, I mean, on SIAs for other commissions, do they apply to commission members? Commission members being considered officers, or is it just for employees?
It really depends on the provision and also the department.
So there's no uniformity.
There's no uniformity.
Or commission to commission.
There is no uniformity, and if you look at actually the SIA for the library, it's only 3A that applies to officers. The officer or employee may be employed by. The other provisions, B, C, D, E, and E, apply to the city librarian, who is an employee, and employees only. So there is a distinction there. And in this case, because the library commissioners do not engage in contract making and and it's really the city librarian or other staff who make those decisions on behalf of the library, my inclination is to keep it like that, to have the B to D, if we're B to E, when we're narrowing the exemption to apply only to employees and the city librarian.
So to just have that one narrow provision apply to the commission members, and the rest of all of this is for employees.
The only problem is that for commission members, I don't know that if we got rid of A, because when we're talking about A, we're talking about really the commission members are not engaged in making contracts. It really does not apply to commission members anyway. So we're really talking about B to E, in maintaining B to E, but narrowing the exemption so that it only applies to sales representative, purchaser, or publicist, and that would only apply to employees. Is that, does that make sense? Anyway, we'll come back with a recommendation.
Thank you, Ms. Singh. Any further comments from the commissioners?
Thank you.
Thank you, Ms. Marion, for your time. Next item on the agenda is consideration of amendments to CFRO. Mr. St. Croix, would you like to introduce?
This document represents an amalgam of a lot of the public feedback that we got in interested persons meetings the work that the staff has done, input from the commission at our last meeting, and meetings with supervisors Campos and Kim and their staff. We've tried to craft something that is acceptable not just to the commission, but to a majority of the Board of Supervisors, a supermajority that is. The elements of this are based in both documents produced by Ethics and by Supervisors Campos, and Supervisor Kim has essentially pulled them all together into a proposal that maintains the best elements of the public finance program and allows us to move forward, but also to accommodate the constitutional restrictions that the McComas decision by the Supreme Court has placed on us. Having said that, the supervisor is here, so I would see if she wants to add anything too.
Good evening, Supervisor Kim. Thanks for joining us.
Thank you, Chair Herr, and also thank you to the commissioners. I know that this has been somewhat of a lengthy process that we've been engaging in since the Supreme Court ruling on Arizona in June. And so we appreciate you considering kind of a variety of different ordinances around public financing so that we can meet to me, the unfortunate U.S. Supreme Court ruling on public financing, really addressing the trigger of disbursement of public funds in response to independent expenditures. Because as the court has stated, they believe that it substantially burdens an independent expenditures on First Amendment rights to speech. And unfortunately, arguments around leveling the playing field and encouraging the usage of public financing, which I think is viewed amongst many of our voters as kind of eliminating corruption and also increasing a candidate's ability to spend time with voters and engaging on important issues, were not viewed as compelling state interests justifying the restrictions on First Amendment speech. Mr. St. Croix kind of alluded to some of the aspects of the ordinance that was brought before you. What came from our office, at least, was, of course, raising the ceilings to really be what was reasonably seen in past elections amongst district elections. In almost every district, we saw that we did have to raise the ceiling in response to kind of the spending that was utilized in each of the races. And I think raising it to $250,000 is reasonable. It's, I think, on average what we had seen. It's not the highest of what the ceiling has been raised to. I think the highest we saw was roughly around $300,000. But we, really considering that there are 11 districts and kind of a wide variety of what the expenditure is, I think $250,000 was a number that we felt comfortable raising it to. Second, of course, most important was taking away the trigger for how we disburse public funds in response to independent expenditures directly in response to the Supreme Court ruling. Second was raising the qualifications to apply for public financing, raising it from $5,000 to $7,500. I understand that the Ethics Commission is interested in raising it to $10,000, and we are comfortable with that, and I think many of my colleagues are comfortable with raising it to that amount as well. And then I know that there are a couple of additional items that you are considering adding to the ordinance that I just want to say that I want to express my support for. As you may know, Supervisor Campos, Supervisor Avalos, and myself have also introduced a potential ordinance to put on the ballot for the June election, just in case we do need to bring this to the voters. And many of the concepts that I know the Commission are considering are ones that are already in the ordinance that we had introduced. One was, of course, delaying any disbursement of public funds until a week after filing date. There are many concerns about people running, applying, and qualifying for public financing, and then realizing when they saw the pool of candidates they're running in that they didn't actually really want to continue running, but felt compelled to continue because they had already received public financing. So we felt that this would address that. We also thought it was important to bring in advance the filing date to June, potentially after the primaries. I think many serious candidates can and should announce earlier, just to get a real sense of what the field looks like for candidates who are considering office. Also, increasing the qualification for incumbents is something that we support. So raising it by 50%, whether it's $15,000 or $75,000 for the mayor, $15,000 for Board of Soups, $75,000 for the mayor, we think is reasonable. If you're an incumbent, you should be able to raise that dollar amount in order to qualify for public financing. We also agreed with taking out the 4-to-1 and keeping it either 2-to-1 or 1-to-1. I know that that was a criticism that was leveled by the public, and I think that that's completely reasonable. And so that's something else that we support. Another point of feedback that we had heard was that the Board of Supervisors was only considering increasing the Board of Soup ceiling and not the mayor's ceiling, and that may look self-interested on our part because none of us are the mayor of San Francisco. I am certainly open to raising the ceiling for the mayoral race. It's something that I kind of leave to the discretion of the Ethics Commission because I think you can look at the data in terms of what has been spent and what is reasonable. Of course, over time, I assume that the Ethics Commission would consider raising anyway as cost of campaigning goes up over time. I think that covers most of what Mr. St. Croix has already addressed. Just wanted you to know that many of the advocates have been working on the different offices on getting a sense of what people would support if this ordinance came back to the Board of Supervisors. I know that several supervisors have also been in contact with Mr. St. Croix and also our office in terms of what they'd like to see. You know, we're really hoping that we can get this out of the Ethics Commission and, of course, the Board of Supervisors so that we can respond to the fix necessary to be constitutional under the ruling. Thank you very much for your time. And if you have any questions, more than happy to answer them.
Thank you, Supervisor Kim, and thank you for working with our staff and with your colleagues to try to fashion a credible and effective solution to this issue. We appreciate that.
No, we appreciate all of your input as well. A lot of the ideas that we heard from the Commission has been really helpful in helping us strengthen public financing as an ordinance here in the city.
Thank you. I'm glad to hear that.
Thank you.
Any questions for Supervisor Kim while we have her?
Oh, maybe just one.
Commissioner Liu?
Thank you, Supervisor Kim, for pulling this together, and I do think we need to respond to the constitutional aspects for a fix here. I did have one question since you raised it on the raising the ceilings for the mayoral candidates. I think at our December meeting we were inclined to do that perhaps, but maybe not as high as, for example, on the expenditure ceiling, not go as high as 1975. Do you have any thoughts on if we went to 175? Would that be agreeable to the board, or?
You know, I can't speak for all of my colleagues. For myself, you know, this wasn't one of the primary driving issues for me. I think that what we saw in the last mayoral race was that the current ceiling worked for at least this year. I think every year, of course, the cost of campaigning does increase, right? And so I think that an increase is necessary in the next 4 years, next 8 years when the next mayor's race is up. So I'm certainly open to a lower ceiling for the mayor's race. So that number is amenable, at least with myself personally. I can't speak for all the members of my board.
Right. Okay, thank you.
Any further questions?
Thank you.
Thank you very much.
Thank you.
Again, I'd like to take public comment on this matter before the Commission deliberates.
Good evening again, Commissioners. Thomas Piccirillo. You know, I appreciate Supervisor Kim's proposed legislation in attempting to make it more in compliant with the Bennett decision. Although I would oppose any increases in the cap amounts for supervisorial or mayoral elections. I don't think there's any data showing why the present caps are not adequate for any individuals that want to run for either supervisor or mayor. As you know, the public financing comes out of the general fund, and we're looking at another $300 million deficit this year, at least. I think that money could be spent more appropriately. So I'm against increasing the cap on public financing for supervisors or mayors because you have no data showing why the present cap is not adequate. Thank you.
Thank you. Thanks, Mr. Hill.
Sure. Good evening, and thanks to everyone who participated in this. I think it's been a good process involving the Ethics Commission, the board, the community to draft something, given the situation with the Supreme Court ruling that we had to make some changes. I think that the raising the caps is appropriate, both in the here and now and into the future. In talking to some of the members of the board, they actually, without using names, one particular individual thought the 1.975 million was perhaps too low. You have to keep in mind that these are supervisors that some who may be thinking about their own mayoral elections in the future. And so, and also a lot of it depends, of course, on whether you have a hard cap or you have the adjustable cap. And so I think that the adjustable cap is also an issue for some of the members of the board that, or the hard cap is something that they don't prefer. But, it's a tough call because you do have public perception issues, as the previous speaker just said, about how much is too much given the current climate. There's also the issue that isn't raised in the memo that I think it is legally at risk to have an adjustable cap of any kind. If you read the Supreme Court ruling in the Bennett case, it didn't say that it was because of the public financing aspect. It was the fact that a privately financed candidate's spending was hinged in some way to a publicly financed candidate, and that it would create a chilling effect by making them think, well, if I spend more money, this candidate is going to be able to get more money, whether it's public or private. So I think that that's an issue that you definitely want to give some thought to. It may not be a reason to not do it because we need 8 votes at the Board of Supervisors, and I think it actually is good public policy to have that adjustable cap if we can get away with it. And it also allows you to track independent expenditures, which is also a valuable service to the community. The one number quibble I would raise is if you look on page 4 and 5 of the memo, when you add up the numbers at the bottom, the incumbents actually end up getting more, $5,000 more in public and private money than the non-incumbents, and same for the mayor's race on page 5 where it's $25,000 more. You could just easily adjust these numbers. So in the public finance raised by incumbents, in that column for one-to-one match of $35,000, if you change that to $32,500, and then the match would be $32,500, then the column at the bottom will add up exactly to $250,000. And the same in the mayor's race, in the one-to-one, instead of a $275,000, if you lower that to $262,500 with a match of $262,500, it will exactly equal the $1.975 million that the non-incumbents receive. I think just from a perception problem, it looks a little odd if the incumbents are allowed to have more money than the non-incumbents. And why go there if you don't need to? Just adjust the numbers a little bit to make those add up. Thank you.
Thank you, Mr. Hill.
David Pilpel, got a number of things to say. Let me try to speed through this. I'm certainly supportive of making changes to the program along the lines of what we've discussed in the past, including at the interested persons meeting. There are things that I like generally about the Kim legislation, and there are things that I'm a bit concerned about. I would actually start in reverse, that the Section 2 that proposes changes to the Municipal Elections Code, although not within the jurisdiction of the Ethics Commission, seems to me to violate the single subject rule of an ordinance, and I would suggest that that be divided into a separate file. It does have impact on the program as relates to the deadline for filing nomination papers. Moving that from E-88 to E-146 adds almost 2 months, 58 days earlier filing, and I would note that that's proposed, as I read it, would affect not just candidates for mayor and board of soups, but all elective offices in the city, including school board, college board, treasurer, et cetera. So on the rest of the legislation, starting on page 3 of the legislation, I certainly support the 10,000, 100 contributors. I would not necessarily leave it at E-70, as I've testified before. And again, this relates to the deadline for filing nomination papers. I would try to move that to E-60 so that it gives somewhat more time. But again, that depends on the filing deadline. I have no...
Excuse me, could you say more time, which way were you?
The idea there is that if the deadline is E-88 to file nomination papers, as it is now, so someone can file until the beginning of August, the E-70 deadline to get sufficient qualified contributions from X number of contributors might be as short as 18 days if they file at the last minute. And there have been instances of that recently. So my thought was, if the filing deadline remains at E-88, that giving it to E-60 or 28 days to gather sufficient contributions in number and value would offer a more level playing field. To the extent that that whole deadline is moved back by 58 days, that changes the whole thing, and I'll have to think about how that works.
I took up some of Mr. Pilpel's time.
I think he still used it anyway. Mr. Pilpel, question for you, though.
I still had some other things, but go ahead with question.
With respect to your first point,
sure.
Can you go over what is the? I think you were referencing something in B about the timing and how it's multiple issues in one piece of legislation.
Yes.
Can you point me specifically to what you're referring to?
Section 2, starting on page 15 of the legislation, proposes to amend the Municipal Elections Code by moving that filing deadline. That is not directly related to the public financing program, and to that extent, I was suggesting that it may violate the single subject rule in the charter with respect to ordinances.
Mr. Shen, do we have is that a, okay. Okay. Did you have other comments you mentioned?
Sure. Again, I have no particular problem with the 15,000 threshold for incumbents, and I agree with Mr. Hill that you can make that change in the third tier to address that. With respect to mayor, I still think that should be raised not just to 50 but to 80,000. And if you use the same 1.5 factor, that would require 120,000 in qualifying contributions from at least 1,200 contributors by a certain deadline if they're an incumbent. I support a mayoral IEC of 2 million, which would apply on page 4 and page 5. The timing of payments on page 7, 142 days. I think that kind of works. I would look at something in that neighborhood that's like 147 or around 150. There's a provision elsewhere, and I couldn't find it in here, that candidates can claim funds up to 30 days after the election. So I was thinking of the program as 30 days post and 150 days pre, for a total of 180 days, something around that. This is close to that, and I think 142 days actually falls on a Sunday. There's a proposal to eliminate the per candidate available disbursement limit. I think that's actually important to retain, because it's not always necessarily the case that there are enough funds in the election campaign fund divided by the number of candidates to provide the maximum allowable funds, and that's why the PCADL process is in the legislation. So I think eliminating that might cause confusion in the event that the fund is not fully replenished. I think that's close to the end.
Thank you, Mr. Pelto.
And I guess on page 14 and 15, with respect to effects of violation, the language could be clarified a little so that it's the mayor may suspend any member of the board for such a violation and seek the removal of the member from office and not the candidate. Although it does suggest in that construction that an incumbent member of the board, if violating the provision, could be removed from office simply for a campaign violation while in office, as opposed to a candidate running who's not attained office. So that's an interesting construction, but maybe
Thank you.
I don't know if I'm reading it correctly. Thank you.
Hello, my name is Hillary Ronan. I'm a legislative aide for Supervisor David Campos, and I just wanted to thank you for the work that you've done and for meeting with our office, and to express Supervisor Campos' support for what's before you today. I did want to let you know that Supervisor Campos' intention would be not to move ahead with the ordinance that is currently before the board to place on the June ballot, to make these very similar changes if indeed you do approve what's before you today, and then of course it gets the approval of the Board of Supervisors. I believe there's only one difference between the proposal before you today and the ordinance that Supervisor Campos has introduced for the ballot, and that's the soft or hard cap difference. And while I think he had a small preference for the hard cap because it was cleaner and the safest way to go, that he understands and agrees with many of his colleagues' preference for the soft cap, and is willing and will support that if that does indeed come before him. So thank you very much.
Thank you very much. Commissioners, comments on the proposed legislation?
Can I clarify something?
Sure.
Mr. Hill had a problem with the way some of these numbers added, and I think the confusion is because there's two typos in those sections, in those charts on page 4 and at the top of page 5. The middle column should be private funds raised by incumbents, and then also the middle column at the top of page 5 should be private funds raised by incumbents. So essentially the reason these numbers are different is incumbents have a penalty. Supervisorial incumbents have to raise $5,000 more than non-incumbents to get the same matching formula. Mayoral candidates who are incumbents have to raise $25,000 more than non-incumbents to achieve the same matching grant, and that's what why those charts are written the way they are.
Although I think Mr. Hill's concern, and you could correct us if we're wrong here, is that as a matter of perception, the incumbent can raise more money, that their cap is essentially higher, even though that additional $5,000 is money they raise from private funds, not public funds. And so as a matter of perception, that could be...
Yeah, well, no. Incumbents get 155 total public funds, and so do...
But they could spend 255 rather than 250, assuming no ceilings.
I see what you're saying. Okay.
If I can add, no, the answer is they may only spend $250 unless the individual expenditure ceiling is lifted. So what we would do as staff would be to advise them, although they may have $255 in their accounts, they may not spend $255. They can only spend $250 until and unless the IECs are raised.
Okay. Commissioner Studley?
I'd be interested in a little discussion about the notion of the higher expectation for incumbents in the first place. And perhaps Supervisor Kim would like to, I don't want to drag you forward question by question, but I was interested in that when I read it and would like a little bit more background on the thinking about why to do that and whether we think it would be defensible. Is that okay?
Absolutely.
Thank you.
Commissioner, am I correct in understanding that your question is why we want to raise the qualifications for incumbents?
Exactly. Thank you.
You know, a lot of the thinking around that was just in terms of the fact that the Board of Supervisors do get to vote on an ordinance that technically benefit us, and I think it was more of a perception issue, was that we would raise the bar for incumbent supervisors. It's not something that I'm personally tied to, but it's, I think, something really for perception of voters around, our public financing laws. I'm sorry, I was not aware, though, that there would be a difference, though. I thought there would be a way to work out the numbers so that it would still only hit the $250,000 ceiling. Might add some complications for incumbents to have that additional $5,000 in their account that they can't spend unless we approve a soft cap for our races. So, I mean, that's a point that I think we're very open to, but it was more to address the concern around supervisors being able to vote on an ordinance that technically benefit us.
So at least based on your understanding, you don't think it would be a significant issue if we adjusted the numbers such that the amount raised for a non-incumbent and an incumbent were at 250?
Yes, I think that would be, for me, something I would like to see. However, I'm not sure if the numbers work out. My apologies for not looking more into the mechanisms of the 2-to-1 and 1-to-1, how that impacted the final dollar amount in a campaign account.
I have a question. Your description is helpful, and it makes me wonder whether there's anything in the opposite direction where this becomes a benefit for incumbents. And what I'm picturing is a real conversation on the ground in which somebody seeking contributions from others says, as they do now, I need your help. Would you please give me a contribution so that I can qualify? And if they have to raise more in order to do that, does that give them a kind of leverage? Or admittedly, it's a responsibility. You have to have the people you can ask. You have to be able to secure it. But it also is, I can't think of any word more technical than oomph. It gives you some momentum. Your question.
Yeah, I have to raise $15,000. I have to raise
Right.
$75,000.
Yeah.
Can you help me
Exactly.
achieve that goal? I would be shocked if any of my colleagues did not raise significantly more than that dollar amount, or did not feel compelled to raise significantly more. So my assumption, even for myself, is that I would feel very compelled to raise a certain dollar amount that is much higher than $15,000 for a reelect campaign. So I'm not sure if my ask would be more urgent, just to qualify.
I tend to agree with that sentiment. I mean, it's at the lowest threshold, and it seems as a practical matter, no incumbent could really hope to succeed.
Right. Yeah, if you take me back to the supervisor numbers, those are
right.
pretty basics. And if it helps us keep the number relatively low for the access number for non-incumbents, I think that is helpful.
For the qualifying threshold? Yeah.
Thank you. That's helpful.
Thank you.
Thanks very much. Mr. Hill, if we could ask you a question again. You had some suggestion for making the numbers add up in an equal way. Can you reiterate those, please?
Yeah. So for the board, if you look at the chart on the numbers on bottom page 4,
right,
there's where you get to the 1-to-1. Under the part for public funds raised by incumbents, which is really private funds, so fix that typo. Where it says 35,000, if you lower that to 32,500, and then the matching public funds would be 32,500, then the total would equal 250,000. You're just getting rid of $5,000.
So essentially, in that scenario, an incumbent candidate who accepted public financing would only be able to obtain a maximum of 152,500.
Right. That's right. It's just a bookkeeping thing. I mean, it's not. And then for the mayor's race, using your current numbers here, same column 1-to-1, if you lower the 275,000 to 262,500, and both for the private funds raised by incumbents and public matching funds, then it brings it down to the same amount. And then the overall matching public funds would be 1.2 million even. I think that's right. Is that right? No.
But it's the same idea, right?
Yeah,
Where
same
you
idea,
would-
right,
You would,
exactly.
you would remove 5.
Yeah, it would be 1,212,500.
It sounds like, and staff, please weigh in here, that would be logistically perhaps difficult to enforce. Not necessarily enforce, but to implement. Any thoughts from the staff on that?
My question is, with respect to matching public funds for non-incumbents, they would be as stated here.
Yes.
Is that correct?
Yeah.
I mean, it's really just, I think, creating a different system, one for incumbents, one for non-incumbents, and the amounts that you would get. I don't.
There's only one incumbent per race, so it's not like you got to track it for
so
a
I
ton
don't
of
see
candidates.
that it's going to be very complicated.
Incumbents, by virtue of their incumbency, have been through the process already, so complicating it for them just a little bit more is not the same as making it more complicated for everybody.
And interestingly, in terms of treating incumbents differently, in the many people I've talked to over the last few months about this, that was one recurring theme. Not that everybody said it, but that a fair number of people said, incumbents already have the benefit of incumbency. Why should they, fill in the blank, get more public money at all? Some of them, or why should it be as easy for them? So I think this, in some ways, does respond to a perception out there that incumbents should have to do a little bit more, work a little bit hard, maybe get a little bit less money than non-incumbents. So in that sense, I think it does respond to that perception.
Thank you. Other comments from the commissioners or questions with respect to the proposed legislation?
I was just going to comment that I do think this proposal here has brought together issues that we've worked through and throughout the last few months in a really coherent way. It's brought together issues responding to interested persons meetings and also takes care of the constitutional fix we need. So I'd be in favor of voting for it.
I have a concern similar to the one that you raised with respect to the cap, it's the soft cap for the mayoral election. To me, the Board of Supervisors number is well supported by the data. It's not the highest, it's not the lowest. It strikes me as reasonable in light of what we've seen. The mayoral number, while it certainly it could escalate to the level of the cap proposed, historically has not been that high. In fact, the winner of this past election spent less than well under the proposed cap. And I understand that, we're looking at another election basically 4 years from now and 4 years after that. So sort of as I supported in the last time around, I think 1.75 is more appropriate. I wonder, obviously, though, we are trying to submit something that meets our goals and also will find support at the board. Is there a procedure for providing a choice for the board to say that, and I don't know if my fellow commissioners would support this, but to put something forth that said, we think 1.75 should be the number, 1.975 would be acceptable?
Not like that, no. You could adopt it as the staff has recommended and then adopt it again with the different numbers and send them both over.
Is that a serious complication?
Well, no, and if you're going to make amendments, I think I'm going to prefer that you do it that way, because then we have lots of We have a number of supervisorial races under our belt, so we do have data from those. We only have one mayoral election, so we don't have the kind of data that we need to make a decision. It may be that the next mayoral race with a non-incumbent takes place in 8 years, and so that's quite a distance down the road. Plus, when the last time we had an open mayoral race before this one, the winner spent in excess, I think, of $6 million. So that number could be much higher. So I think that I would recommend that you, if you want to make that change, do so, but then adopt the identical proposal as it is. Send them over to the board, and the board can use its process to determine which of those two proposals they prefer.
Okay.
And our discussion would indicate which one we prefer.
Right.
If they, that they could take that into consideration.
Right. And my view on it is in part influenced by the soft ceiling. I would understand in a hard cap situation the concern is much stronger, that you need to set a limit that is actually realistic. In a soft cap situation, even if the total, even if the soft cap is turns out to be a little bit low 8 years from now, a candidate could still compete by raising private funds. But Mr. Shen, it looked like you had something.
Just one suggestion, really. Just as a matter of procedure, you could approve two versions of the ordinance out of tonight's meeting. But in a quick sidebar I had with Supervisor Kim, she expressed a strong preference for a single option coming out of tonight's meeting. That it would just be, obviously after this proposal makes it out of tonight's meeting, if something does make it out, it really is on her office and some of her colleagues to really move it forward through the process. And I think as a practical matter, it's easier for them to handle one option or one proposal as opposed to multiple proposals.
I see.
And that's true even if the proposal is not identical to what has been proposed here. Is that sort of?
Yeah.
Sure. Please, Supervisor Kim. Sorry, we're bringing you up here multiple times.
And I appreciate the discussion, the dialogue. It is my preference that we get one ordinance back to the Board of Supervisors. And I think around the mayoral ceiling, I think we really look at the expertise of the Ethics Commission to kind of help determine that number. So whether it's 1.7, 1.9, I think that there's a level of deference that my colleagues will have in terms of that final number coming before us. Yeah, I think there's some disagreement, but not a very strong disagreement about the hard versus soft cap. I've generally heard slightly more support for the soft cap.
I would like to discuss the soft cap a little bit. Have you said everything you've said about why you think the soft cap is the better approach? I know that's what you're.
My reading of the ruling was that the Supreme Court was very specific that it was the trigger of the public funds disbursement that substantially burdened the First Amendment rights of an independent expenditure. I know that because there wasn't a specific ruling to that particular issue, it's hard for us to say. And I know we have several attorneys on the commission, so I'm sure that you have your opinions as well. I think that the general feeling is that a soft cap is more fair. If there is an independent party that decides to throw in an inordinate amount of funding again, opposing your candidacy, I think it's only fair that you should be able to privately raise dollars. I think it's very different from the other public financing schemes that we've looked at. It doesn't involve any public funding disbursement, and so I think that's why there's a slight preference for that dollar amount. We partially addressed that with raising the ceiling. I counter some of the points that there isn't data to support that. I think in every race we've had to raise the ceiling, and we reached a number that we thought was fairly reasonable to kind of run a credible campaign that can get you actually a seat on the Board of Supervisors or in the mayor's office. But I've generally heard kind of a soft preference, just in case there's a kind of unlikely, well, I don't want to call it unlikely, just a scenario where you're really vastly being outspent in a race.
There are two considerations that have been important to our interest in having the system in the first place, and I wonder if you could speak to how you think they play out here. One is the governmental interest in participation in a publicly financed campaign system in the first place. Do you think that the soft versus hard cap will make it more likely that candidates will feel comfortable or safe participating in races down the road?
I think definitely when you're looking at candidates that are considering what route they're going to go down, their ability to compete will play a factor in whether they decide to take public financing or not. And I know that, much of kind of the practices or specifics that we put into this law was in order to encourage as many people as possible to participate in public financing. And I think we've really seen that too. And every year there's kind of been an increase in the number of candidates that have participated in public financing, which in many ways I think has been important in quote unquote, kind of creating similar budgets amongst a variety of different campaigns. And of course, allowing candidates to really spend time with voters. Having run for office, fundraising takes up an inordinate amount of time when you're running and can really take away from the time that you can spend door knocking, doing visibility on the streets, and really interfacing with what voters would want to see. It certainly freed up my time, and I think I had a much stronger sense of what the district wanted and some of the goals and priorities that they had for the district because I was able to spend that time doing that groundwork.
So you're saying that that's with respect to the soft cap, that the soft cap would give you the flexibility to run a more viable campaign as a publicly financed candidate?
It would allow us to be competitive as a publicly financed candidate. There would be no disincentive in being a part of a program that I think allows candidates to really be more part of a democratic process with voters.
And so you think that it will, given your feelings about that, other candidates would be likely to either hear from incumbents that this was effective and worth and secure enough to be willing to participate in the public financing program?
I believe so.
Mm-hmm. Thank you.
Thank you,
No other
Supervisor
questions.
Ginsburg.
No, thank you.
Thank you.
Further comments or thoughts from the commissioners?
What you need.
So if you're going to go with the 1,750 cap for mayor, if you just change the one-to-one match from 275,000 to 162,500, that will lower it to 1.750. I think I've done the math right. Yeah. So in the one-to-one match, right now it starts at 275,000. So get rid of the 275,000 and just lower that to 162,500. And then the match would be the same amount, 162,500, and that comes to a total of 325,000, which, going with the numbers up above, comes out to 1,750,000.
Mm-hmm.
But double check my math.
Sure, and we'll make sure, I mean, if we go with something like that, we would obviously make sure the math was right. Commissioners, how do you feel about the threshold for mayor? I mean, I am personally a little torn about it. I mean, I do appreciate Mr. St. Croix's statement about what was spent in the mayoral election prior to public financing, and that, certainly it's hard to predict for the next contested election what the right ceiling will be. It seems like a lot of money either way. The difference, perhaps, at that point is a bit on the margin. So I am.
Mm-hmm. I think based on the data that we have and based on the discussion we had in December, I'd probably be more comfortable with a 175 as opposed to raising it all the way to 1975 without more data supporting that number.
I support the lower.
The lower number.
amount, yeah.
Commissioner Sedley, any?
I'm inclined toward the lower number. I think that the one of the voters' purposes here was to try to restrain spending. Restrain, but hold some, yes, limits on spending. So in the absence of a record that gives us some other number to work from, that's the one I would tilt in that direction.
Commissioner Ham?
The question I have is as we approach the next mayoral election, are we able to revisit the amount and change it, or then is it basically written in stone at that point until we make official changes after the election?
As we are working on today, we are free to go back and change the ordinance, but as always, you need a supermajority of both the Ethics Commission and the board. So these changes are always going to be very difficult.
So not a simple matter.
Right.
I still favor the lower amount.
And this would be still sticking with the soft cap, right? I mean, that would make more sense to me if we did the lower amount especially.
Likewise, I mean, I think there are concerns, constitutional concerns about the soft cap, but I think sort of in light of what the decision says and where the precedents have come out to date, to me, that's a risk worth taking. And what about the issue of equalizing the amounts for incumbents and non-incumbents? Are we in agreement that the number should work out so that an incumbent would earn $2,500 less, have a $2,500 lower ceiling on publicly available funds, so that the total amounts that they could spend would be the same and there wouldn't be any campaign surplus to deal with, assuming there was no expenditure cap raise?
That makes sense to me, too.
Okay, so then, is there a motion to amend the CFRO as proposed, subject to the following changes? Adjusting the, for an incumbent for the Board of Supervisors race, there would be an adjustment in the matching funds to $152,500, and an adjustment to the one-to-one match from $35,000 to $32,500, whereby an incumbent candidate and a non-incumbent candidate would both be able to raise a maximum of $250,000, subject to the IEC e-ceiling being raised. With a further amendment that the mayoral ceiling be similarly adjusted to reflect a total cap of $1.75 million, with the one-to-one ratio similarly adjusted such that the $1.75 million would apply both to an incumbent candidate and a non-incumbent candidate for mayor.
So moved.
Second.
All in favor?
Aye.
You have something to say?
Yes.
Mr. Pilpel?
Yeah, just 2 points. I think it should be made clear, and I'm not trying to, influence the vote here, but just to clarify, that the two charts here don't take into account contributions that aren't matchable. So in practice, the total theoretical match of $155,000 never really gets achieved unless the IEC is raised and there's more matchable contributions, because you're always going to have friends and family from out of town and other out of town contributions or things that aren't matchable. And some of the other proposals that were looked at in November and December had a line for private funds not subject to match. These charts don't. So
I think we all understand that
Okay.
these would be only matching funds.
and theoretical. And the other question that I had, if you're going to the 1.75 on the mayoral race, what amount is the public funds cap that's now 1.225? What would that go to? I think that's important for you to make clear. And I have not done the math that Mr. Hill has suggested.
I think that goes to 1.075. But again, I mean, I would leave it to the staff to make the corresponding reduction based on the motion.
They'll figure it out, I'm told. Okay, thank you.
Okay, the motion was seconded, just so the record's clear. All in favor? Aye.
Aye.
Opposed? None opposed. It passes 4-0. Thank you for all of you who came and provided valuable input. And again, we thank the staff and supervisors and all those who participated. I think this was a helpful process that we engaged in pretty quickly, and Godspeed. The next item on the agenda is a budget discussion. Mr. St. Croix, would you like to introduce this?
Yeah. This recommendation is become somewhat customary for our commission. For the past several years, the city has had quite a difficult budget situation. And at issue are two things. One is we've been requested to make cuts by the mayor's budget office. But at the same time, the Ethics Commission is an independent agency, which has a slightly different status than other city agencies. Because we're moving to a 2-year budget cycle, the target was to cut 5% off of this year's budget for next year, another 5% for the following year, and also to provide a 2.5% contingency. The 5-year plan of the Ethics Commission would require more staffing, among other things, for us to be able to meet our entire mission. Because of the budget situation, that's extremely unlikely. So out of respect for the city's budget process, and also acknowledging the Ethics Commission's independence, I'm recommending that we put in a request that's just equal to this year's budget and would allow us to go forward pretty much with the same staffing level we have now. If we do endure budget cuts, it will mean staff. There are no other accounts with any sufficient funds to meet the targeted cuts. So it would mean an immediate loss of staff for next year and then additional loss of staff the following year. Obviously, we would respectfully work with the Mayor's Budget Office and the Board of Supervisors through the budget process for the rest of this fiscal year to come to some kind of eventual agreement.
Thank you, Mr. St. Croix, and thank you for working, I think, very effectively with the staff that you have and considering all the budget cuts. I think you guys are doing a great job.
I would mention that our budget analyst was here for a while, but I guess he had to go.
Public comment on this matter?
David Philpell, I would note that this is actually a 2-year budget, so it's both 2012-13 and 13-14, although the memo isn't so specific, and the calendar item actually is not that specific. There is a public hearing requirement for budgets, and the caption isn't that clear. So if you're intending to act tonight, rather than in February, since the deadline is prior to your next meeting. I would support the staff recommendation. I think it's important, though, to include some narrative in the transmittal that explains to some extent what the existing resources permit you to do, and what reducing the level of resources would mean in terms of loss of staff, and on the other end, what additional resources would permit you to do. So I think that makes a good argument for the middle position of keeping things roughly as they are, that we're not getting everything done, but we're not getting nothing done. I think that would help. The memo doesn't detail the existing staff and non-staff costs, and actually if you're having to produce a contingency cut, I would immediately offer televising of the meetings as being something to offer up. I continue to think that it's a bad idea and waste of funds, much as I love SFG TV. But as we've seen tonight, everyone's gone other than us. Thank you.
Thank you, Mr. Pilpel.
But we have no idea the scope of the audience out there on
Thousands
TV.
are watching. In fact, people come up to me every day and say, I see you on TV. And I think that's unfortunate. And thank you.
You got a bill.
Perception, David.
Yes.
Comments or questions from the commissioners on the budget request?
These are tough times, but I think it's a reasonable balance of the independence of the commission and respect for the city's budget situation.
Is there a motion to approve the budget request?
So moved.
Is there a second?
Second.
All in favor? Aye.
Aye.
Opposed? Passes 4-0. Minutes from the Commission's December 11th, 2011 meeting. Public comment?
David Pilpel. It was actually the meeting of December 12th, so that is correct on the draft minutes, but not on the agenda. I can mark up the minutes if you'd like. There were a couple of instances of other typos. Page 5, decision point 6. I think that should be Executive Director St. Croix. There were some other instances that could be made slightly more clear. The attached 150-word statements, I think that's fine, but I would suggest adding what agenda item each statement was in relation to, because there were several from an individual that don't track easily. So just indicate that that was submitted in connection with item whatever. And finally, the closed session doesn't have the detail that's required under the Sunshine Ordinance as to who was present in closed session. So that too could be added. Again, I can mark it up and give it to the staff, but they're really just minor.
Commissioner Studley?
I agree with Mr. Pilpel's suggestion that the statements from people who present to us would be clearer if they just indicated the Roman numeral of the issue that they were related to when they spoke. On page 2, there's a word missing within the summary of Mr. Hart's comments. I believe on line 4, it should be aid students to pass a real estate exam. And in 2 comments involving my remarks, on page 3, third from the bottom, I think it would be a little clearer if it said that would allow the commission to provide a $5,000 match if a candidate raised $5,000 with a larger number of contributors than currently required, or while increasing the number of contributors, something like that, to indicate that mechanism. And then, if you would indulge me on page 8, items for future meetings. I believe, or at least intended, my comment under that item to be a suggestion. So Vice Chairperson Studley suggested that the Ethics Commission consider at a future meeting whether to initiate. So I wasn't stating that we should, but suggesting that we, within that heading, that we bring it up for discussion. Thank you.
Any other comments with respect to the minutes?
I'm happy to move their adoption as amended and subject to minor technical corrections.
By Mr. Pilpel. I only have one question with respect to Mr. Pilpel's proposed revisions. What is the requirement with respect to indicating the individuals who appear before us in closed session?
I mean, if there's a
I assume that there's no
matter
problem
of confidentiality
identifying the people, but I want to make sure before we.
Sure there is.
Yeah.
It's confidential who appeared at public in private session?
Isn't it the case that if it's a probable cause situation and we find that there is not probable cause, that the person's, that we have an obligation of confidentiality?
I can just summarize by saying that the Sunshine Ordinance provides that those present in closed session need to be identified except where their identification would interfere with other things. So you may rewrite that to say it was the members present, the staff, the city attorney, and an unidentified individual or something, but just some language about who is present. That would work.
Thank you. I think
but I'll leave that to staff's discretion to sort out.
Yeah, I mean, if it were legal advice, then you'd put the participants, but I understand it might be different with probable cause situation.
Yes. Thank you.
So is there so subject to all of that, Commissioner Sedley's made a motion. Is there a second?
Second.
All in favor?
Aye.
Opposed? There's none. Motion passes. The Executive Director's report.
Okay, just one highlight. We do want to try to have our joint meeting with the Sunshine Ordinance Task Force in February, so I'll be asking you to comb your calendars with suggested dates. And I anticipate this being either a daytime meeting or a meeting early in the evening starting at 4 or 5 o'clock. Something like that. But we first have to identify the dates that rooms are available, then the dates that commissioners and members of the Sunshine Task Force. So it's going to take a little doing, but now that we are in the new year, as stated, we will move ahead on that.
Thank you very much. The next item on the agenda, public comment. Thank you. On the ED's report.
David Pilpel, just two items. On page 3, the status of legislative proposals, the Cohen legislation that was referred to earlier, since that has not yet had a hearing or, to my knowledge, been scheduled, that won't be able to take effect prior to the February deadline when candidates could, under current law, apply for and be certified for public financing. Does the staff have an intention or need direction about how to proceed in the event that a candidate does raise funds and seek certification while that legislation is pending? Because in theory, they would be subject to the current law and current rules. That was kind of an open question. I suppose it depends in part on when that redistricting task force gets its work done. But anyway, I'll leave that there. Thanks.
The next item on the agenda is items for future meetings. Commissioners? Public comment? Public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission. Is there a motion to adjourn the meeting?
So moved.
Is there a second? Commissioner Hand seconded. All in favor?
Aye.
Aye. Opposed? Meeting is adjourned.
you.